で、も本日はお集まりいただきありがとうございます。本日はモダル社のブライアンを、お招きをしまして、こちらの書いてあるケース、インプットデバイスゲームコントローラーというものもレビューをしていきます。では皆様よろしくお願いいたします。
よろしくお願いします。
ブライアンお願いします。
はい。So I'll go ahead and get started, I guess.
Yeah.
Okay. Why is it not doing it? Oh, there it goes. Okay. So today we are discussing a game controller, and we'll begin with some background. In this game controller, if it's okay with everyone, I'm going to take off my mask so that you can see my lips. In a game controller, when a multi-directional input section, for example, an analog stick, is operated, the shaft portion of the multi-directional input section comes into contact with a housing, thereby limiting motion of the multi-directional input section. And so the invention here is that when a force is applied to the key top of an operation member in the left direction, the operation member is tilted to the left side and moves in a peripheral direction on the left side of an opening portion. And we'll show this on the next slide. Then within the housing, an extremity of a protruding portion comes into contact with the contact surface of a pedestal. This will be color-coded. And thus the operation member is not tilted anymore in the left direction. And so at this time, a shaft portion of the operation member does not come into contact with the first housing. That's the solution to this problem. And so at the top, you can see the quote again from the solution. And on the right side of the slide, you can see how it does not come into contact. The red portion circling where the key top portion does not come into, or the operation member does not come into contact with the side surface. And you can see how the extremity is touching the pedestal at the bottom of the left side when the operation member tilts to the left. So how are they claiming this invention? You can see it on this slide. I've added reference numerals so that it makes a little bit more sense. This is an edited version of the slide, so we're leaving out some unimportant portions. And the first thing I want to call your attention to is the red circled colon. This is the first colon in the claim, and I believe this significantly impacted prosecution. The reason is that the attorney appears to believe that this is where the transition from the preamble of the claim to the body of the claim is located. And as I said, we'll talk about that more momentarily. And I've maintained the color coding of the green and yellow portions from the previous slide. We're only looking at claim 1. Claims 14 and 15 are also independent, but differ only in terms of preamble. And so while claim 1 is a subcombination apparatus claim, claims 14 through 15 basically are combination apparatus claims. So what does the prosecution look like in this case? Well, in the first office action, the examiner rejected, in part, claim 1 as anticipated by the Huang reference. The office action states its reliance on figure 4b. We'll talk about that momentarily. And the applicant conducts an interview in which an amendment is proposed. Specifically, during the interview, the examiner and the applicant determined that figure 4c is the more relevant figure. So, it shows you the value of an interview right there. Specifically, they clarify that the rejection of claim 1 is as it's shown on the right side of the slide. Again, I've maintained the color coding so you can see how our claim is supposed to match to this figure. And the interview results in a small modification to the proposed amendment, and we'll show that on the next slide. But for now, the important part to notice is that when the Huang joystick body 21 tilts to the right, the second protruding edge 24 on the left side, circled in green, contacts the first protruding edge 311, circled in yellow, on the left. So it's when one side goes to the right, the other one touches at the top on the left, which is the opposite of what we're trying to do. And that's what's shown in our proposed amendment here. There are a couple of portions here. The first one I want to call your attention to is this kind of middle portion where it says that the contact portion 42 is configured to limit movement of the operation member when it moves in the peripheral direction. And then we've got this last part, and that's really what I want to focus on here. And this last part clarifies that the contact is in the direction in which the operation member is moved, right? On ours, we move to the left, we contact on the left. In Huang, we move to the right and we contact on the left. So now we're saying that a side of the protruding portion, that is in the peripheral direction of movement of the operation member contacts a side of the contact target portion that is in the peripheral direction of movement of the operation member. That's how they're claiming it. If we think about how objects rotate around their centers, though, this amendment is the functional equivalent to structurally defining that the contact is under the operation member rather than above it, right? So if we think about, let's take this, something moving like this, if it contacts on the right, it's going to be on the upper side. If it contacts on the left, it's going to be on the lower side. And so instead of saying it's on the same side, or underneath, and therefore on the same side, we're saying that it contacts on the same side, which is the same as saying it contacts underneath. In the prior art, it contacts on the upper side, which is the same as saying it's on the opposite side, right? Because it's rotating around its center. Of course, it's important to notice, though, that functional equivalents are not the same for patentability or eligibility purposes. And we'll see that in this case, actually. The reason, the way that they've claimed this becomes significant. So in their response, applicant added 9 new dependent claims. There was some room for dependent claims, so this only resulted in governmental fees of $400. There were basically 3 groups of dependent claims. The first one is claims 16 through 18. And these relate to the key top, the protruding portion, and the shaft portion of the operation member. I didn't really understand what was going on here because the specification says that the shapes of these 3 elements are merely examples, and these components may have other shapes. So it's not, particularly important how they're shaped. The prior art reference that was applied here teaches the features of all of those claims. And the only explanation I can think of is, as I said earlier, a misunderstanding of the claim preamble, right? If you think that the invention, if the applicant or the applicant's representative, more likely, thinks that the invention is the operation member, pardon me, then it makes sense to claim these elements. But if you believe that the invention is the entire housing, you wouldn't normally choose these elements. And so I'm not really sure what value the applicant receives from these claims, right? They've paid some money. if claim 1 remains rejectable over some new reference, we'll call it reference A, then 16 through 18 at least are rejectable over reference A in view of Huang. Right? We already know that Huang teaches these elements, so we know that there's, unless this case is allowed, these claims are just going to get rejected. And we can see that new claims 19 through 21 and 22 through 24 recite the same features, but depend instead from independent claims 14 and 15. But those are combination claims, as I said before, right? They have basically, they only differ by preamble. And so we've got this situation where claims 14 through 15 are not of a different statutory category, right? Frequently, they are of a different statutory category. We've got methods, we've got computer readable mediums. Here, these are just the same apparatus claims. The dependent claims read identically. And so even if we accept claims 16 through 18 as relevant, I'm not sure what value the applicant receives for claims 19 through 24, right? I mean, they mean the exact same thing as 16 through 18. The applicant receives a second office action from the examiner. Amended claim 1 is rejected as anticipated by Arita. The rejection is shown in annotated figure 12A of Arita to the right. And the applicant conducts an examiner interview to argue that Arita only describes protrusions 12A coming into contact with rim 2AC of cover 2A. So this is shown on the right side, really. We've got the purple portion of the protrusions coming into contact with this red circled portion of the rim. That's what we're expecting this interview to be about. And so to help overcome that, the applicant proposes new dependent claims 25 through 27 relating to portions of the operation member. But instead they receive this alternative rejection, as shown to the right side of the slide here. Instead of focusing on the upper right corner, now we're looking at the lower left corner. Because again, it's the rotating around the center, and now we're underneath this area of rotation. Oops, sorry. And so in particular, you kind of have this portion here where on the right side that the examiner points to explain how that works. And specifically, the examiner relies on Arita housing 8A, bosses 11A, and protrusions or tabs 12A as teaching the claimed contact target portion, the side of the protruding portion, and the side of the contact target portion. Okay, you can kind of see how this thing's going to move and like bump into the base in the lower right corner. In reply, the examiner indicates that the claim is not limited to, quote, only the protruding portion in the peripheral direction contacting the contact target portion. It's not. That's clearly not in the claim. And that seems to be why the examiner is saying that this reference discloses claim 1. I didn't include the dependent claims here, but regarding proposed new claim 25, the examiner seems to agree that Arita does not show the stick shaft extending from the stick main body part. I'll show you why later. But for now, I can tell you that I can't explain why. This is pretty clearly in the reference, in my point of view. The only thing I can think of is that the examiner believes that this proposed claim requires these elements being separate. The claim doesn't say they're separate. I don't get it. And instead, the other thing that happens, additionally, during the interview, the examiner proposes claim language to clarify the feature of only the protruding portion in the peripheral direction, contacting the contact target portion. The specific claim language that the examiner proposes is something like the side of the protruding portion opposite, so the opposite side of the protruding portion, does not contact the contact target portion. And this becomes relevant in a moment because the applicant amends that there are independent claims that way. Specifically claims 1 and 14 through 15. These are in line with the examiner's suggested amendment. To be clear, there are some small differences like antecedent basis that was changed, but basically they just said what the examiner said on the previous slide. They also add new independent claims 25 through 27, corresponding to interview claims 25 through 27. So they've taken these dependent claims, they've written them in independent form, and they did not include the currently amended features of claim 1. And so because they're adding 3 independent claims, this incurred government fees of $1,740. This was pretty expensive for them. To be clear, these are broader than if they had kept dependent claims 25 through 27 in dependent form, right? Because we've narrowed claim 1. And so, they would also be narrower because of that amendment. But the examiner indicated, the examiner did indicate that these would overcome the rejection, but he did not indicate that they were allowable. Okay, so, if we're overcoming the rejection 2 different ways, but we're not necessarily getting an allowable claim. And so I don't really see why they're being presented in independent form, right? You could have kept them in dependent form and had a fallback position or something. And now it's just extra fees for something that might not matter or might create difficulties. In their response, they provided some remarks that created estoppel. We talk about this a lot. What does it look like when you characterize the references? How do we avoid estoppel in our arguments? And so these are examples of how estoppel is created. So for example, they said that, there's this feature that can be seen in figure 12B of ARITA, where the upper right protrusion 12A is in contact with the rim 2AC of the cover 2A. That's not in ARITA. ARITA doesn't say that. ARITA doesn't necessarily show that. Their remarks continue by saying that, since this contact is excluded by claim 1 doesn't say that that's excluded. I see why they said that, but that doesn't mean that that's right. And so as a result, adverse parties can rely on these admissions by the applicant, right? This can be a licensee, this can be someone that's trying to invalidate your patent, this can be the examiner. They can say now that ARITA 12B shows this contact. They can say that claim 1 excludes this contact. I'm not sure how that would impact any particular position, right? I don't know what, some inter partes review is going to look like. But I can tell you that, now you've made invalidating your patent easier, or you can argue non-infringement easier. The remarks also never argue the patentability of these new independent claims, right? The examiner said that it doesn't seem to be shown. Again, I'll tell you in a few minutes. Well, I think that is shown in the art. But this is an example of something that's non-compliant, right? The examiner really should have issued a notice of non-compliant amendment here. You have to argue the patentability of your new claims. The examiner issues an advisory action indicating that the application may be subject to a restriction requirement. This is because we're adding these new independent claims. And we've got now two different sets of independent claims that don't really have so much in common with each other, at least in terms of how they overcome the art. The applicant responds correctly by filing an RCE, but they maintain their current claim set. So they don't change their claims to avoid this restriction requirement. So when they file this and prosecution reopens, the expectation is that they'll receive a restriction requirement. Instead, the examiner just moves on to the next office action. He maintains his rejection of claims 1 and 14 through 15, as well as all of the dependent claims 16 through 24 that were added earlier. And basically, the lesson that the applicant learned is that the examiner's proposed amendment during the interview was insufficient. Okay, the examiner got his own reasoning incorrect, but somewhat surprisingly, claims 25 through 27 were allowed. In terms of generating their response, the applicant conducts an interview, but we don't really know what happens. There's not really a discussion by the applicant. There's not really a discussion by the examiner. All we know is that the applicant amends claims 1 and 14 through 15 based on the interview, and they try to put this in condition for allowance. If you look at the actual filed documents, this amendment looks quite substantial, but it's just what I've shown here. It's much shorter than what it looks like in the filed documents. And so basically, it now just reads, wherein the contact target portion and the protruding portion are structured such that the side of the protruding portion does not limit movement. They're kind of taking this like struck out portion and moving it up a little bit in the claim. Or I'm sorry, they're actually just broadening it in a lot of senses. So it appears that what the issue is that the previous claim was unclear whether the movement is limited by the side of the protruding portion or the side of the contact target portion. That's the best guess I have as to what this amendment accomplishes. This is what I was talking about before when I said, we're going to see how claiming this functionally instead of structurally impacts the prosecution. This is where they try to address that problem. The one comment I have about this proposed or this filed amendment is that the phrase about being structured a particular way, they're adding that there, are structured such that, that doesn't really help the applicant. That doesn't mean a whole lot. And we'll talk about that now. So the question is, okay, this resulted in a patent. Brian, why don't you like the allowed subject matter here? So first, I want to address the original independent claims, 1 and 14 through 15. As I said a moment ago, we can see that we've got this added portion. And I want to call particular attention to the portion in the yellow highlighting. First, this being structured portion, we've got both the contact target portion and the protruding portion being structured this special way. So, both of these are limited now. And we also have this part where we talk about not limiting movement. And so, okay, well, who cares, Brian? Like, what do you have in mind? Well, you can see over here on kind of the left part of the image, this is from our application. This is where ours looks like. And on the right side of that image, This is part of what the prior art looks like, flipped it upside down. And I'm saying like, okay, well, what if we put these tabs on there to kind of create this embodiment where, we limit movement a little bit, right? It's going to kind of fit into these slots, these tabs. And could a competitor implement that pictured modification? Well, sure, but why would they do that? Like, why did I come up with that? Well, that's actually something that's specifically mentioned in our application. This isn't just something a competitor could do. This is something that the applicant thinks that a competitor could do. And if you look at the pre-grant publication in paragraph 118, they talk about this guiding that can occur in this location. And that's what I think this is. This is the guiding that they have in mind. And now, they've got this claim amendment this allowed claim that doesn't seem to cover one of their embodiments. So I thought that was a little unnecessary. In terms of these other allowed claims, this is that part I was talking about showing you that I didn't understand why it's in there. Again, we've got the color coding between green, yellow, and blue. We've got the stick main body part and a stick shaft extending from the stick main body part, and the stick shaft being connected to the shaft portion. Well, if you look at the right side, you can see that, you've got the green portion and the blue portion that extends from it, moving up from the bottom. And then that connects to the shaft portion, the yellow part on top. I don't get, like I said, I don't get why this is allowable. I think this is very clearly in the art. The only thing I can think of is that, this is a unitary unit on the right side. And maybe the examiner believes these have to be separate or something. These are discrete components, or I don't get it. I mean, I don't get it. The other issue with this allowed claim language is the use of the present tense verb, being connected, and that kind of suggests a method of manufacture. I don't necessarily personally agree with that. But this is the sort of thing that, an infringer might argue, or someone that's trying to invalidate the patent. They're going to look at that. They're going to say, this is a method of manufacture. You're mixing statutory classes. The claim is invalid. And, the applicant, the patentee, is going to have to defend against that accusation. So what's the proposal? Well, this is the original claim 1 again. The thing that's missing is the pedestal. This seems to be the focus of the invention. The contact target portion is supposed to be the pedestal. But if you look, the only limiting portion is being within the housing and coming into contact with the protruding portion. So basically, the structure of the contact target portion is unclaimed. I think I need to speed this up a little bit. So I've got at the end of the presentation, we're not going to have time, a list of the other dependent claims. The one I want to focus on is claim 13. It looks complicated, but it's just claiming these relative relevant relationships between the operation member and the contact target portion. It looks narrow because it's so long, but they're kind of necessary to producing the invention. The examiner says in his rejection, he just points to like a big portion of Huang and says it's in there. If you know your US prosecution, you might think that we would argue this MPEP section, right? Arguments based on measurement of the drawing features are of little value. But we kind of have this issue where, there's this inequality that seems to be satisfied, right? We're not going to actually do measurements, but it looks like this is met. So what do we do? Well, Brian, you're kind of being disingenuous here, right? You've got yellow minus green on one slide is less than purple and blue. And on the next slide, on slide 28, you said green minus yellow is less than that. And so you've kind of played a game with us here, right? The left sides of the inequalities are different. Yeah, I get that, but what does the claim say? Well, the claim says that there's this difference between L3 and L4, right? And it doesn't say what that difference is. There's different ways of defining that difference. And so maybe Huang is sufficient to show that relationship. So how do we address that? Well, now we just, instead of saying a difference between L3 and L4, right? Because it could be subtracting L3 from L4 or subtracting L4 from L3, we just say which one we mean. We're going to say it's a difference from subtracting L3 from L4. This is the specific relationship in our claim or in our invention. This specific relationship is not what's shown in Huang, right? They show the opposite. And now we can rely on that MPEP section, right? We know that that measurement's not in there. We don't have the breadth problem in our claim. And, if you look at the next time the examiner rejects that claim, he did apply a different reference. That has the same inequality as Huang. So we would present the same argument.